is Official Towing Incorporated. Looks like there may be another defendant, Midwest Auto Auction, as well. Your appearance for plaintiff in this matter, do I have Correll Bryant or counsel for Bryant on this Zoom at this time?
Yes, Your Honor, Peter Conway on behalf of Mr. Bryant.
Repeat number for the record, Mr. Conway. Thank you.
23260.
All right, thank you. Good morning to you. For the defendant, Official Towing Incorporated, your appearance at this time, please.
Good morning, Your Honor. Nicholas Bashand, P67447 on behalf of Official Towing.
Thank you, counsel. Good morning to you. Do I have counsel for Midwest Auto Auction on this Zoom?
Yes, Your Honor. John Badine, P71014 on behalf of Midwest Auto Auction.
All right, thank you, Mr. Benin, and good morning to you as well. All right, gentlemen, I know we're a bit behind schedule here. It looks like there is a motion to transfer the case back to 36th District Court. I noticed this is a 2019 matter, so it's been going on for a little while. So somebody tell me about that.
Yes, Your Honor. I had originally filed a motion to change venue. Your Honor ordered that change of venue to St. Clair Shores based on the offices of defendant Official Towing, I believe. I never received a copy of that order, and in looking at the docket, it appears that the currently listed counsel for my client is outdated. So the case transferred to St. Clair Shores. We didn't pay the filing fee because I didn't know that it was due. Mr. Conway had filed a motion to transfer back based on the failure to pay the filing fee. That motion was granted rather expeditiously without even making it to hearing. And when I was doing my research on the matter, I realized that under the court rule, failure to pay the filing fee is kind of a strict liability issue. So that there's no ability to actually keep it there. It was moved here. Mr. Conway actually called me at 9:34 or so this morning because I did not even receive notice of today's hearing. But my intent all along was, once I was made aware that this file was back in front of Your Honor, I was going to renew my motion to change venue, but I'm about 30 minutes back into the case, Your Honor.
All right, and so basically it's back here because of some type of error in transmitting the notice of transfer such that the fee could be paid, correct?
Yes, Your Honor. I didn't know when it was going to hit St. Clair Shores, when it would come off of Your Honor's books, end up on their books, thereby triggering the duty to pay the fee.
Well, Your Honor, we disagree with that contention. This course, of course, sent out the notice after the hearing, as this court always does. And we just followed up with St. Clair and said, okay, you've got the file. Has the money ever gotten there? And they said, no, the statute is quite clear. And I don't believe the statute allows for a second go round for the same purpose. So I think where we're at is that the appropriate thing to do, since there's not been discovery since the amended complaint was filed, is to give us 90 days for discovery and otherwise issue a scheduling order in this case.
Surprisingly, Your Honor, I actually agree with Brother Counsel on 2 points. The docket does reflect that the order was mailed out, but unfortunately, the docket also reflects that a Robert Shefferly is the attorney for Midwest Auto Auction, not myself. So I don't know where that would have gone. And I also agree, and that's why I didn't file a motion to renew or reconsider in St. Clair Shores, because the statute doesn't allow it. If the filing fee is not paid, it's absolute. It has to come back here. I haven't looked at the issue of filing again because I found out about this hearing 5 minutes after it was commencing.
And counsel, anything you wanted to add to this matter? Or official?
I would just say I got a call from St. Clair Shores saying we have this file, and then a day later I got a motion from Conway, and then 3 days later I got an order from the court saying we're sending it back to 36th District Court. So the whole intent was either to be in Redford or St. Clair Shores. This court said St. Clair Shores. Nobody had an issue, and I'm pretty sure Mr. Badine has no problem paying the fee. So we've been in this court on this case over and over for the last, it's before 2019. This thing started in 2016 or 2017 on the same issue. So I know you're packed. I don't see why not trying to go back to St. Clair Shores and get this thing over with.
Several responses, Your Honor. First of all, I don't believe there's a state.
Mr. Conway, let me stop you. I think I've heard your responses in this regard, and I think the heart of this whole thing is, Mr. Bedin's claim to the court that he came in as counsel somewhere along the line and never received the notice regarding transfer, and that it certainly would have been his intent and effort to, in fact, pay the fee. And that seems to be where the issue is here. Other than that, it seems to me that there's a lot of dragging along here, missed opportunities to litigate the matter. And, I don't like it any more than anybody else here. But if the case should be somewhere else, and the failure for that case to sit there now is secondary to counsel as an officer of the court indicating that he did not receive notice as the counsel for that particular entity, then it would seem to me that that this is a situation where I should, in fact, on his renewed oral motion in front of this court, transfer the matter back where there's a finding that Mr. Alley, you need to mute yourself. Where there's a finding that that counsel for defendant option did not receive the notification such that he could have complied with the order. That seems to be the challenge here. And before I make any final determination on that issue, Mr. Conway, I will hear from you now, sir.
Thank you, Judge. First of all, I believe that this case, and believed at the time that we argued it before, should be retained by this court. As far as the transfer goes, we all know that things are supposed to take place within certain time periods. We're all aware of the court rules. We're also aware of our own obligations to make sure that the records are correct. And in this particular case, apparently, brother counsel did not do that in this case. The material got sent over. The statute is quite clear, and as he indicates, it's not a case of intent. It's a case that the wording of the court rule is very clear. And so I believe for all of these reasons that this should be retained in this court.
All right, the board listens to the arguments with regard to the matter and the motion before the court. And the court has been apprised by the respective counsels of the history of this matter. I do not believe that the rules regarding the change of venue anticipates these scenarios where clearly it was the intent of the court to grant the motion and for the matter to be transferred to the appropriate court, and that was in fact done. But one of the predicates was not satisfied, and that is the payment of the fee. Counsel, as an officer of the court, Mr. Dean, has indicated that he was ready, willing, and able to pay the fee. And notwithstanding the fact, as Mr. Connolly points out artfully, that this matter went on for a while, Mr. Bedin says that he did not receive notice. And I suppose that a reasonable argument could be made that by reasonable inspection, he could have discovered the notification. But at the end of the day, the issue is whether or not this case should be before that particular court in St. Clair Shores, and whether or not its failure to be there is secondary to anything other than a simple error that can be corrected at this time. I suspect that it was there that the matter is back here now, and I will allow an order transferring the matter to the St. Clair Shores District Court, one of the fine places where I practiced many years ago. And I'm thinking that this is not the same oyster. It must be his son from back in the 80s. But anyway, I'm going to send the case back there. I'll sign an order consistent therewith, and the FEMA pay as required by the court rules. So, right, good day, gentlemen. All the best.
Thank you, Your Honor.
Your Honor, very briefly, just housekeeping, so I don't miss something again. Your Honor is drafting an order and signing it today, so I should be prepared to get a check over to St. Clair Shores in a week or so.
I'm always happy to draft orders, but I'd like for you to submit an order to me. I'm going to give you the email address where you can send that today. I'll sign it and mail it back to you, and you can distribute it to the appropriate people. That email address is Latifah, LATIFAH dot, last name is Hunter, HUNTER, at 36districtcourt.org.
Thank you very much, Your Honor. Just want to make sure I'm more on the ball this time.
All right, thank you, and good day to you. Good to see each of you.
Thank you very
Good
much.
day.
Always a pleasure.
The court now calls case number 19. That's. All right, the court calls case number 22-187-984. This is case management versus USAA underwriters. The matter is before the court, set on for a hearing on a motion for summary disposition. The court set the matter for a pretrial conference as well. Your appearance for the plaintiff in this matter, please.
David Kane appearing today on behalf of Gregory Young, the attorney of record.
Good morning,
P33-265.
All right, thank you, counsel. Good morning to you, sir. For the defendant in this matter, please, your appearance at this time.
Good morning, Judge Chad Ushinsky on behalf of defendant USA Underwriters.
And good morning, Your Honor. Amber Gearbaugh, P73448 on behalf of defendant MAIPF.
All right, Mr. Dushinsky, let's get your P number on the record, if you will, sir.
Sure. P81872.
All right, thank you, counsel. Good day and good morning to each of you. I do see a recent substitution of counsel, and I note that there is a motion pending for summary disposition regarding this matter. Looked like I set this up for a status conference today. Somebody let me know if, well, it doesn't look like I issued a scheduling order previously. Is that correct?
Correct, Your Honor.
All right. So the motion for summary disposition in this matter, defendant Michigan Automobile Insurance Placement Facilities. That's your motion. Is that correct?
That's correct, Your Honor.
All right. Have you guys talked about any of this? Anything needs to be brought to my attention before addressing the motion?
Your Honor, if I could, as I indicated earlier, I'm standing in today for Mr. Young. Mr. Young advised me that today was only a status conference. The notice of hearing I have in the file for the motion for summary judgment says it's to be set for a time and date determined by the court. So he told me today was just a status conference. I'm requesting Mr. Young is out of the country. I'm requesting that the court adjourn the motion for summary disposition. I'm not prepared to argue it. I don't believe Mr. Young has even filed a response yet because he believed it was up for a status conference today.
Yeah, kind of what I had in mind until I looked at it, saw that it was a status conference. Oftentimes, when I set up a scheduling order, the next action date, the pretrial post discovery, is usually a date that I allow for motions to be heard as well. So I kind of thought that this was of that nature. But it was filed back in July, and so I'm a little bit troubled that there has not been an answer filed under the court rules. Madam Counsel, any position at this time?
Your Honor, I have no desire to jam anybody up. If for some reason they didn't understand that the motion was today, I have no issue having an adjournment and allowing them an opportunity to respond.
That was a setup question for you. You passed the test. All right, very well. So I will adjourn the motion over to the date that I'm going to set for discovery cutoff. My inclination is about 60 days of open discovery and allow the parties to proceed accordingly. Now, if additional time is needed, I'm kind of lenient when it comes to those things, as long as the party says it's moving forward. What I don't care for at all is, 60 days of discovery, 60 days pass by, nothing's been done, and additional time is needed. That's not a favorable position to take. So I will set it up on a schedule of 60 days open discovery. Now I have a return date of
November 17th.
November 17th, 2022, and that's going to be at 9:45 a.m. You will get a notice with that date of November 17th at 9:45 in the mail. You also will get a scheduling order. The scheduling order will provide that date as well as the date of cutoff for discovery. It will also provide that motions filed before this court will be heard on the date set for the pretrial conference. And if you file any motion, I know that there's one already filed, but if any other motion is filed, the only requirement is that you provide at least 10 days notice to the opposing party prior to the hearing date. It can be a dispositive motion or non-dispositive motion, doesn't matter. If you file your motion, set it for hearing on the date, the new, strike at the pretrial date of November 17th, I will hear the motion on that date. So the motion that has already been filed, I will hear that motion on the 17th of November. Any other motion that either party may file, as long as you give the other side at least 10 days notice, I will hear the motion on the pretrial conference date. That is notwithstanding the typical court rules. The court has set the time frame for responding based upon its order that you will receive in the mail in the next few days. All right. So that's going to be the way that we're going to proceed. Any other issues we'll take up at another time. Anything at this time?
I'm all set, Your Honor.
All right. Thank you.
Nothing further.
Thank you.
Thank
And
you.
Mr. Duchesky, I know that you didn't have much to engage on this occasion, but we'll see you on the next occasion. We'll get notices out to the appropriate parties. Good day to you.
Thank you.
Sounds
Thank
good.
you.
Thanks, Judge.
The court now calls case number 22-179262. This is American Express National Bank versus Deborah Lewis. The matter is before the court, set for a status conference. The court is in receipt of the answer to the complaint, so the matter is joined before this court. All right, your appearance for the plaintiff in this matter, please.
Yes, good morning, Your Honor. Attorney Jason Brainer, P69653, on behalf of American Express National Bank.
All right, thank you, Mr. Brainer, and good morning to you, sir. For the defendant in this matter, Ms. Deborah Lewis, your appearance at this time, counsel.
Gary Strauss, P48673.
All right, thank you, Mr. Strauss, and good morning to you, sir. I note that the claim in this matter is for damages in the amount of $3,656.16. And this is, of course, alleging a breach of contract. Have the parties had an opportunity to talk, the attorneys talked about this at all, to see if there is some traction for trying to get this resolved at all?
So we have not, Your Honor. However, our firms do a lot of business together, and we have a pretty good relationship and track record of working out such matters. And so typically, during a period of discovery, be it 60 or 90 days, we'll come to some sort of resolution. And I'm sure opposing counsel, brother counsel would agree with me on this, that if we do a scheduling order with maybe 90 days limited to written discovery and a cutoff date for dispositive motions, we should be able to resolve it.
Yeah, I agree, Your Honor. I'm still waiting for them to build up funds so we can make a plausible offer and hopefully resolve this.
All right, very well. Sounds like a reasonable course to take. All right, so what I'm going to do is I am going to set it on a 60-day discovery path. And I'll give you that date of the 17th of November as a return date. regarding this matter. And gentlemen, you've heard me go over provision 6 of my scheduling order. It provides that if you have a dispositive motion or non-dispositive motion, you can schedule it for hearing on the 17th of November, 2022. And I will hear the motion on that date, so long as you give the other side at least 10 days to respond to any motion that you might file. Now, this does not preclude the possibility of you filing motions in the future beyond that date. Doesn't cut you off from doing that, but if you wanted to get something in front of me and as an act of efficiency, then you could set it up to be heard on that same date, that pretrial date, post the discovery. So that date's going to be November the 17th, 2022, and I'm going to set this on at 10 o'clock a.m. 10 o'clock a.m. on that date. You're going to notice, in fact, the date and time will be in the scheduling order, and you'll get another separate notice with that date and time as well. All right, so I wish you well, gentlemen. A good day to you.
Oh, thank you. Appreciate it.
All right,
Thank you, Your
thank you. Same to you, Your Honor.
Honor. See you, James.
All right, take care, Gary.
This is case number 22-184-141. This is Midland Credit Management versus Danielle Hudson. The matter is before the court set on for a status conference. Your appearance at this time for Midland, please.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
Thank you, Ms. Strickhardt. Good morning to you. And let's see if I have Danielle Hudson on this Zoom. Looking for Danielle Hudson. If you're on the Zoom, please say something at this time. I do have an answer file in this matter.
We never received it, Judge.
All right. The reason then, and that's why we set it up for hearing, because we did receive the answer. Is dated the 16th of June. Basically, it says that the amount is not right. No record of disputed charges, but it seems too that the defendant is not present. We did send out a notice to the address that the defendant used in submitting her answer, and that address is on Sutherland Street in the city of Detroit. The notice gave her information regarding the Zoom and the hearing on today's date. She has not appeared. Counsel, your position at this time, please.
Yes, we would move, Your Honor, for a default judgment for the relief as prayed for in the complaint, namely principal damage totaling $1,509.04. This was a 2-count complaint, Judge. Costs of filing fee of $55, motion fee of $20, service fee of $65.10, totaling costs of $140.10. We are not requesting any attorney fee, Judge. So the total judgment we are asking for is $1,649.14, with the 6-month statutory rate currently resting at 3.46% from the date of entry of the judgment forward.
Thank you, Counsel. All right, given that the defendant has not appeared, the court will make the finding that the defendant is in default regarding this matter, and the court will enter a judgment on that default upon its submission to the court on the terms as requested. And so, Counsel, you'll want to email that to the court. And
yes, I have the Latifah.hunter@36districtcourt.org. Your Honor, I will have access to the email tomorrow. Is tomorrow morning early enough for the court?
That's fine.
Thank you so much, Judge. Have a wonderful day.
All right, likewise. Good to see you.
Good seeing you.
All right, and this is case number 22-182-827. This is Latyra Reed versus Ben Bantos and AD Motors Auto Sales. Looks like two separate defendants here. All right, the matters before the court set on for trial regarding this matter. Your appearance for the, do I have the plaintiff with Tyra Reed on this Zoom? Ms. Reed, if you're on the Zoom anywhere, please say something at this time. Matter set on for 10 o'clock a.m. It is now 10:32 a.m. For defendant counsel, your appearance at this time.
Yes, good morning, Your Honor. For the record, John Ollie, P number 37913, appearing on behalf of the defendants.
All right, thank you, Mr. Ali. So have you spoken with Ms. Tyra Reed this morning, or any efforts to reach out to you or anything along those lines, sir?
No, Your Honor, I haven't. And I would note that this case was originally dismissed, and then the court reinstated it, and we appeared in early August, and there was no resolution, and then it's set again. So, you know, she sort of had a couple bites at the apple here. When it was originally dismissed, the court essentially acknowledged that she really didn't have a valid claim, but you know, she had a 90-day warranty. It expired. It was an as-is vehicle, and you know, she didn't pay a lot of money. And you know, you buy a vehicle with a lot of miles on it, you know, you're gonna have problems.
Yeah, I kind of remember this, of course, and then I look at the complaint and it reminds the board that, of course, it was a vehicle that was purchased with 126,000 miles on it. And some of the service that was requested was after even a 90-day warranty. She claims to some extent that there was a delay beyond some of the things she requested beyond the 90 days. The fact of the matter is that it has been dismissed before. Defendant is plaintiff is not here and has not notified the court of any difficulties. For that reason, I will grant your motion to dismiss this matter, and the case will be dismissed at this time.
Thank you, Your Honor.
Good day to you.